Minister in the Office of the Attorney General and Legal Affairs.
Madam President, I thank you sincerely for the opportunity to contribute towards this bill this afternoon. Madam President, the bill before us today is necessary in a contemporary and a modern society. It is absolutely necessary in a world such as ours, where young people, Madam President, and children are amongst our most vulnerable. Madam President and my brothers and sisters of this Senate, I do respectfully say that this anti-gang bill, it is not a if, it is not a but, it is not a maybe, it is a must if we are to put a handle on criminal activity, especially criminal activity that affects children in this country. Madam President, I use the word vulnerable with certitude. As in my previous incarnation as a defense counsel, and I will share a very personal story with Trinidad and Tobago and this Honorable Senate. In my previous incarnation as a defense counsel, I recall, Madam President, appearing in my first criminal matter, a fresh-faced attorney at law, eager to learn. I distinctly recall going to the prison to meet my very first criminal client, a 14-year-old boy. Madam President, the scariest thing is to look into someone's eyes and see absolutely nothing. The scariest thing is to look into a child's eyes and see almost a soulless being. This young man, I will never forget. He said to me the best he ever felt was when a gun was placed in his waist. He said to me, and I will never forget, he said, the best feeling, and I'll put it exactly as he said. He say, I'll tell you. He said, the best feeling is walking down that square and knowing, boy, I could wipe out a man. I felt like a god. And this story remained with me because it was a 14-year-old boy saying to me that this is what empowered him. Now, this young man, Madam President, he was a part of a renowned gang at that time. And yes, I did secure an acquittal for him, and I applauded myself as a young defense counsel at that time. But now, in retrospect, I ask myself, did I really save that child? Yes, I secured him an acquittal, but did I really save him? Madam President, honestly, in retrospect, I don't believe I did, because what I did is I released him, as Senator Vieira said, I released him to the wolves that were still existing outside there in our society. The wolves that were waiting with bated breath to bring him back into gang culture. Madam President, I did not have a full opportunity then to truly save young men like this 14-year-old client of mine. But now, serving in the capacity in which I do as a minister of government in this parliament, I believe I now truly have an opportunity to save those young men who cannot save themselves. And this anti-gang bill, I truly and completely believe it's one way in which we can save our young men, especially young men from shattered communities in our country. Madam President, we must save them. With this legislation, we can save them. There are provisions in this bill to save them. This is our legislative intervention in an attempt to put a handle and suppress crime and criminal activity in this country. You know, I've heard many talks about the stats not looking good. But I want Trinidad and Tobago to ask themselves, I want our citizens to ask ourselves, what are we to do then? Simply sit by and do nothing because the stats don't look good on paper? We can't. As a government, it's our responsibility, Madam President. It is our responsibility to use legislation as the current one to at least for the very least to suppress criminal activity in this country. Now, there are many points that Senator Mark would have made, but I would leave this, I would address those comments in my winding up, because there are certain areas of the law that I want to address and put into the public record as it relates to this particular bill. If I may respectfully, Madam President, take my colleagues to clause 15 of the bill that appears before us, I will pay specific attention, Madam President, to clause 15.1 and 15.2 of the bill. Now, clause 15, Madam President, in essence, it deals with police powers of entry, search, and seizure. And 15.1 specifically states that a police officer may arrest without a warrant a person whom he has reasonable cause to believe is a gang leader, a gang member, or who he has reasonable cause to believe has committed an offense under this act. Now, why I've personally plucked out this particular clause is because I want to deal with the issue of reasonable cause. Because for some reason, there seems to be people in the public who believes that we are giving the police unlimited powers and there's no control. So to answer your question, Senator Vieira, you made a point, Senator Vieira, and I'm starting with this clause because you are correct. There are checks and balances on the police. And even within this legislation, there are checks and balances. And that check and balance, one of those checks and balances, is found in the legal term coined reasonable cause. Now, I want the record to reflect, Madam President, that police officers cannot just arrest a man or arrest someone on a VAPS. They can't wake up one morning and just decide I'm going to take down a man because he's a gangster or a gang member. We understand as legislators on this side that the area of contention is that people, as I said before, may believe, or the public may believe, we are giving the police extended powers. But if I may respectfully address the case or allude to the case, Madam President, of Nigel Lashley versus the Attorney General of Trinidad and Tobago. Now, this was a particular case adjudicated upon by Justice of Appeal, Judge Justice Narain. And in this particular case, Madam President, Justice Narain dealt with the issue of reasonable cause and its meaning within the confines of the law. And he stated he was in full support of the principle of reasonable cause. Now, in that very same case of Nigel Lashley, Justice Narain also made mention to another case known as Dallison and Caffrey. Now, Dallison and Caffrey was a case which was adjudicated upon by Lord Diplock. And Lord Diplock, in that particular judgment, he said that the test for reasonable and probable cause has a subjective as well as an objective element. He went on to say that the arresting officer must have the honest belief or suspicion that the suspect had committed an offense, and this belief or suspicion must be based on the existence of objective circumstances which can reasonably justify the belief of suspicion. This, in essence, Madam President, is not an officer operating on a VAPS. It is not an officer operating on a whim. It is not an officer operating on a fancy. So by us inserting the clause reasonable cause, even though we are widening the hub and scope of the powers of the police, it must be done within the confines of reasonable cause. Now, Madam President, if I may even take us to our jurisdiction, a police officer need not have evidence amounting to a prima facie case, but at the same time, he must not act on a mere gut feeling. And that was actually taken from the case of Rupert Narain versus the Attorney General, which is a local case. Now, the High Court, Madam President, in this particular case of Rupert Narain, went into broad detail as to what was suitable to determine the arresting officer had a reasonable and probable cause to arrest someone. Now, in determining the issue in this particular case, the court took into account factors such as the nature, sources, and quality of information. The court illustrated the degree to which police officers had to be cautious in treating information before them. So by quoting these case laws and by defining and explaining what reasonable cause is, Madam President, what I'm saying is that, and by importing the term reasonable cause in this particular piece of legislation, what I'm saying is we are not legislating insanity by giving the police wide discretion in arresting. The police officers are going to be guided by the definition of reasonable cause within the parameters of the common law. Now, the brilliant Attorney General, Madam President, in his wisdom, understands the parameters within police officers will have to operate. And as a result of that, was very mindful to include that provision in this particular section of the bill. So while we are increasing the police powers, we are doing it within the parameters of reasonable cause.
Minister, Minister, if I could just ask you to lower your voice a little.
Yes, Madam President. I'm surprised Mr. Roberts is not here. Senator Roberts. Madam President.
Senator Lyda, please desist. Continue, Minister.
Yes. So, Madam President, that in essence is one of the major reasons why 15.1, I believe, was crucial for me to at least explain, so that at least we can place into the public the understanding that we are not simply giving the police an unlimited amount of powers. They are going to be restricted by the definition of reasonable cause within the parameters of the common law, settled common law that exists in our jurisdiction. Now, the Attorney General, Madam President, would have indicated that there are amendments which will be brought to 15.3. So I will not look at that. I will now respectfully take my colleagues to 15.2 of the bill, which is before us. Now, 15.2, clause 15.2, Madam President, I'm dealing specifically with the issue of constitutionality here. Now, clause 15, subsection 2, goes on to say that a magistrate under his hand may issue a warrant to a police officer authorizing the police officer to enter and search a dwelling house where a magistrate is satisfied on evidence on oath that there is reasonable ground for believing that there may be found in the dwelling house a gang leader and so on. Now, again, if I may address my colleagues to another case. There's a case of Central Broadcasting Services versus the Commissioner of Police. This particular case, Madam President, went on to quote another case by the name of DPP and Barnes. This case alluded and explained what was the concept of a dwelling house. And it was noted that a dwelling house is much more, Madam President, than brick and mortar. It is a home of a person, and it must therefore be afforded protection in law. Now, because, again, as legislators, we have recognized that a house and a dwelling house ought to be treated very differently. Even though, again, while we are giving the police increased powers, we have ensured within the parameters of this legislation that the powers that the police has is limited when it relates to entering into someone's dwelling house, recognizing that that is where we may trip over issues of constitutionality if we just tell the police, well, yeah, you could ride up on a man, go into his house and do whatever you want, right? So we have made provisions within 15.2, Madam President, as it relates to dwelling houses. If I now may analyze and make a contribution, Madam President, to clause 16 of the bill which is before us, and this particular section, Madam President, this clause deals with the issue of detention. Now, clause 16.1, Madam President, it speaks to the powers of police officers to detain a person without a warrant for 48 hours. The officer, as stated in the bill, must have reasonable cause to believe that the person who he's seeking to detain has committed or is about to commit an offense. And we all have seen the bill, so we know what the clause reads. Now, Madam President, I understand that the detention of a person, it may be argued, is a prima facie tortious case. And some may argue that it's even an infringement on Section 4A of the Constitution of Trinidad and Tobago, and that speaks to the right of a person to liberty. Now, Madam President, I submit respectfully that the justification for 48 hours and the police's ability to detain for 48 hours can be found and is referred to in several international comparators. So, for example, if we look at the general comment number 35, Article 9, called Liberty and Security of a Person, of the International Covenant of Civil and Political Rights, we see in that particular article, 48 hours to detain someone was deemed as reasonable and not being unconstitutional. Another international comparator, Madam President, is the recommendation Reg 2006 in brackets 13 of the Committee of Ministers to Member States on the use of remand in custody, the conditions in which it takes place, and the provisions of safeguards against abuse. That's a very long article. This came out of the European Council. This is another international comparator that spoke about the 48 hours not being unconstitutional to remand someone, to hold someone, Clause, if I may respectfully read Rule 14 of this particular international comparator, it stated that the lapse of time between the detention of an individual and the individual's rights to appear before a judge should be no more than 48 hours. It was stated that the interval between the initial deprivation of liberty and the appearance before such an authority should preferably be no more than the 48 hours, and they recommended 48 hours as being a sufficient time frame. So that's international comparators. So in Trinidad, by presenting this bill and speaking to the 48 hours, we are not departing, Madam President, legally from what the international position is. Even if we look at case law, we have the case of Dallison and Caffrey again. That particular case, Justice Stallmeyer in particular, said that while there is no statutory provision restricting the period of detention, in his wisdom, he alluded to the use of 48 hours as a guideline. So again, by us including the period of 48 hours, it is within the parameters of this bill, it has not departed from what learned judges in different jurisdictions would have alluded to. Even recently, Madam President, Justice Lisa Ramsumir-Hines, I distinctly recall, in a written ruling dated the 1st, 2019, I believe it was a matter of the application of Dinesh Durga for the detention order. I believe it was under section 17.4 of the previous Anti-Gang Act. That was the 2018 Anti-Gang Act. Now, the clause in which he challenged was the section which Dinesh Durga challenged was section 17.4 of the 2000 Act, and that is now clause 16.4 of the bill which is before us. And Justice Ramsumir-Hines, in her wisdom, she said inter alia that 48 hours is a maximum period that can be used for detention. She also advised, and from the judgment, she advised that in cases of all the detentions under this act, within the first 48 hours of arrest and detention, the police should be acutely sensitive to the need to conduct their investigation diligently and expeditiously, and went on to give some suggestions as to what the police should do within those 48 hours of detention. Now, what is incredible is that if we read lower down into this section 16, for example, if we look at section 16.3 of the bill that is before us, we have legislated what the police is now required to do during that time of detention. So Justice Ramsumir-Hines would have made mention to this since in 2019, and in this bill, we have legislated that. So we are saying to police officers that while you're detaining a man or woman for 48 hours, these are the checks and balances, these are the things that has to be done during that period of detention. And that is alluded to, as I said before, Madam President, in section 16.3 of the bill which is before us. Now, if I may take my colleagues to clause 16.4 of the bill. 16.4, Madam President, it gives the police the right to seek an order for continued detention beyond 48 hours, where it is necessary for preserving evidence and all of that. Now, this also practically is a fundamental and very important provision in the bill which is before us, that provision where the police now can knock on the door of the court if 48 hours has lapsed. And And it's very important from a very practical perspective. So, for example, you may have cases where the police may arrest someone on a Friday evening. You take them down, let's say under this bill, if it becomes an act. And you carry that person down, but you have not been able to proffer a charge yet because you're still in the process of conducting an investigation. Now, to be able to lay a charge, what may be required is some forensic evidence, some ballistic evidence. You may require a substantial amount of evidence to be returned to you as police officers before you could actually proffer the charge. What this extension does, sometimes to get that evidence now may exceed 48 hours, and that's why I use the weekend scenario. So sometimes you might take down a man, you take him down on a Saturday evening, and it's difficult to get a forensic report, or it's difficult to get a ballistic report within that 48 period. So what you have now is the police now, Madam Deputy President, Deputy President, is that Vice President, what we have is there is now an opportunity of the police to knock on the doors of the judicial officer asking for an extension of time beyond that 48-hour period. And this is absolutely crucial in a practical sense. And therefore, we have to, again, commend the Office of the Attorney General. We have to commend the Attorney General for, in his wisdom, including this provision for an extension of time. I mean, even as lawyers, we find ourselves sometimes in a bind. In civil matters, for example, we have a 28-day period to file a defense. And sometimes there are just circumstances of evidence coming in late, the client is unable to get information to us, that we are required to knock on the door of the court, ex parte as well, to make an application for the court to grant us, for the court to decide whether they're going to grant us an extension of time. I think it was Senator Lakshmi Dayal spoke about her concerns about the ex parte application. And even at a high court level in civil matters, we can make ex parte applications, and it's for the court to decide, it's for the judge to decide, based on the application that is before him or her. If it is one, and I have seen where I've made personal ex parte applications, and a judge may look at the evidence or the application and say, no. I need the two parties to appear before me before I grant whatever it is that you are seeking ex parte. So we have not locked out in this particular, even though we have said in this provision that an ex parte application can be made. An ex parte is an application for the public. It's an application that can just be made with one party appearing, not both parties appearing. Even in an ex parte application scenario, a judge still has the discretion to decide that, okay, I'm looking at the facts, and I don't think this is sufficient evidence. I need both parties to be present in this particular hearing. So this is to elude any concern, because, people may hear the word ex parte, and don't understand what we're talking about. Certainly, we're not tripping over any constitutional rights of anyone by saying that this application for further extension of time can be made by an ex parte application, Mr. Vice President. So this is as it relates to Clause 16.4 of the bill that appears before us. If I may now respectfully take my colleagues to Clause 6 and Clause 13 of the bill which is before us, I personally am very, very happy and in full support, 100% support. I guess being a past teacher, being a mother of a young boy as well, for this particular provision, because it refers to the recruiting and coercing of young people into gangs. Now, I would like to consider, as I said before, this Clause 6 of this bill, in conjunction with Clause 13, as it provides for the recruiting of a gang member. Now, Clause 6 specifically states that a person who coerces, encourages, entices, aids, and abets another person to be a gang leader, a gang member, commits an offense and is liable on conviction and indictment to imprisonment for 25 years. Clause 13.1 goes on to speak about a person who recruits another person to a gang, commits an offense and is liable on summary conviction to imprisonment. And then Clause 13.2 goes on to speak about a person who recruits a child a child to a gang also commits an offense, and it speaks to what they are liable for. On a summary conviction, to imprisonment for 15 years, or on a conviction, on indictment, to imprisonment for 25 years. Now, this particular provision, in particular, it pulled every single heartstring that I have as it relates to child offenders, as it relates to persons preying over children and trying to coerce children into joining gangs. And the reason for this is because I'm not sure if any of us recall the case of Joshua Andrews. And Joshua Andrews was a case in about 2018. And my father at that time, he was the senior superintendent for the Northeastern Division. He was in charge of the entire division. And my father, for most of my life, was for my entire life, he was a police officer. At that time, he was in charge, as I said before, of Northeastern Division. And it was the first time in my entire life I ever saw my father came home after a matter dealing with an issue, and he looked totally winded.
Senator, you have 5 more minutes.
Yeah, thank you very much. It was as if he could not contain himself. And that particular matter, while he was not the investigating officer in the matter, the child who was killed during a gang crossfire, which is Joshua Andrews, attended a school which fell within the Northeastern Division. And my father would have had to go to that school to counsel some of these children. And I will never forget, he came home and he said, "You ever hear somebody cry from their belly? You ever hear somebody cry because they're feeling pain from their belly?" And I think, and it was because the children, the other students in the school who had known Joshua Andrews, that had affected them, that assault and that murder of that child had affected them so tremendously that not even my father, who had so many years of experience, could have handled that. And this particular clause, this particular clause, I respectfully submit, it has the ability to protect our children. It has the ability to protect those little boys who do not have the ability to protect themselves. There are many young men outside there, we all understand, that they lack father figures in their households, and they turn to gang leaders because they feel a sense of belonging. It is our responsibility as a parliament to protect those who cannot protect themselves. And I'm saying this to ask my learned brothers and sisters of the independent bench to give our government the full support in this anti-gang bill. Yes, the statistics may not show an insurmountable amount of convictions, but it could certainly play a part in suppressing criminal activity. It can certainly play a part in suppressing gang activity in this country. It is our responsibility, I respectfully suggest, and I will continue to say it, to protect those who is not in a position to protect themselves. And I'm asking my colleagues, the honorable senators of the independent bench, to please, notwithstanding, we may need to amend certain parts of the bill. The Attorney General said that he's open to conversation. But the possibility of suppressing gangs and saving a child who cannot save himself because the adults who were supposed to save him did not save him or did not protect him, we may very well be able to do that with this bill that is presented in the Senate today. So to that extent, I know I did promise that I would respond to some of the comments made by Senator Mark. I know Senator Mark said that this government, we're dealing with law and we're not dealing with the social issues as it relates to young people. I would say that this government didn't only just develop a social program to help young people. We created an entire ministry to help and save young people. And that ministry is found in the form of a Ministry of Youth Development. I know Senator Mark spoke about his theory on SRPs and all of that. I want the record to reflect that the recently passed SRP and PCA bill that was brought and passed last week in the House, it was our intention to put it is the intention of that law to place SRPs on the same footing of even police officers. I know he quoted some statistics, but I also have stats which I want to put in the public record. For example, in the Trinidad and Tobago Police Service, we have an audit of 524 male officers, 1,859 female officers, as opposed to the SRP audit, which for males, there is 357 part-time male officers and 242 female officers. Also on the SRP audit, and this I need to place in the public record, is that for male officers, full-time male officers, there's 2,913 officers and 864 female officers. So in total, the TTPS, we have about 6,983 officers, whereas the SRP, there is 4,376 as the total figures. Now, Senator Mark, I recall he made a recommendation as to amendment that he wants the police to provide the report, the station diary extract or something to that effect. He wanted us to legislate that. I want Senator Mark to know that under the standard process of disclosure, this is allowed. So with these few words, I fully support this bill, and I ask the learned colleagues of the independent bench to give us the support that we require. Thank you very much.